Welcome, everyone, to the Federal Bar Association Key Tam Sections, The Rounds, FCA News with Tejinder Singh. The Rounds is Tejinder's regular analysis of noteworthy FCA decisions. I'm Scott Oswald. I am program chair of the Key Tam section with Tejinder Singh, who is a partner at Sparacino PLLC. Tejinder, hello.
Hey, Scott.
So today we're going to start with a new case out of the 10th Circuit. It is U.S. ex rel. Tracy versus Emigration Improvement District. And this case has a couple interesting issues, one of which deals with the False Claims Act statute of limitations. Tell us about the statute of limitations first, Tejinder, and then how the court ultimately applied it in this case.
Yeah, so as we all know, the False Claims Act has kind of a two-parter statute of limitations. There's the 6-year statute of limitations, which is sort of your default, or you can go 3 years after the date the government might have known, but no more than 10 years after the violation occurred. And so that second one is kind of like a discovery rule coupled with a statute of repose. And it effectively, in most cases, creates a 10-year statute of limitations because most of the time the government will not know about frauds that are being pursued under the FCA. And so in this case, the question was, what starts that 10-year clock running? Is it the submission of the claim for payment, or is it when the government pays the claim for payment? Which is not an issue that actually arises that often, because most of the time, you're going to sue well within 10 years of both dates. But this was a weird case where those two things happened a couple of weeks apart, and the relator sued 10 years, about 10 years later, and it was in time if it was the date that the government paid, but it wouldn't have been in time if the relevant date was the date the claim was presented. And so the defendant said, well, this is untimely because the violation occurs when we present the claim. And the 10th Circuit agrees. The 10th Circuit says, yeah, damages are not actually an element of the claim. The claim has accrued at the moment it's been presented. And if you read the section 3729, that's kind of what it says, right? Liability attaches to the presentment of the claim. The relator said, yeah, but I'm pursuing a claim for damages. And so my claim didn't accrue until the damages happened, which happened at payment. And he cited a case from the Court of Federal Claims, which held as much. The 10th Circuit said, nah, I'm not buying it. We don't think so. We don't think damages are an element. Your claim accrued earlier, so your claim is untimely. So the lesson in this for everybody considering bringing a claim closest to the statute of limitations is you really ought to make sure that you're getting it in by the time claims were presented. Don't rely on the dates of payment as the potential dates for the time clock running.
And that wasn't the end of the 10th Circuit's work. It then goes on to consider the fee petition that the defendant submitted in the claim. But they didn't make the claim that the relators had interposed frivolous claims. It was something else. Tejinder, what happened?
Yeah, so in this case too, this is the rare case in which a defendant sought fees from an unsuccessful relator and got them. The statute provides a mechanism for this, but it's rarely utilized because it imposes a pretty high burden on defendants. They have to show that the claims are frivolous, vexatious, or brought for purposes of harassment. In this case, the court finds that the claim is vexatious and brought for purposes of harassment. It catalogs some harassing behavior by the relator. And the relator says, oh, no, but my claim's not frivolous. And the 10th Circuit says, doesn't matter if your claim is not frivolous because you had these sort of improper motives behind it. It's actually really interesting that a claim that's not frivolous, wasn't found to be meritorious, but they didn't reach the merits because of the time bar, was just also deemed bad enough that you could have a fee award. Pretty unusual situation, but an important cautionary tale, I think, for relators counsel as well, because sometimes you have these clients, who are difficult and who may have an axe to grind with the defendant, and that can expose you to some fee liability.
Tejinder, let's turn to the Supreme Court and what's going on at the Supreme Court. The court denied certiorari in Johnson versus Bethany Hospice. Tell us what the state of the law is in the wake of the Supreme Court's denial of cert in that case.
Yeah, so Johnson was one of 3 cases at the Supreme Court presenting the same question, which is about whether Rule 9b requires relators to describe specific false claims or details of false claims, or whether it just allows them to plead the details of fraudulent schemes without pleading the details of claims. Both plaintiffs and defendants were arguing that there was a circuit split on this question. And so there were 3 different cases that came up, 2 from relators, 1 from defendants. The court denies certiorari in all of them. In the wake of that, the circuit split remains as split as it ever was. Is there a chance that the courts will converge over time? Maybe, but they've had a long time to figure this out. And if anything, it looks to my eye like they are diverging, that certain courts are going in the direction of a stricter rule and other courts are sort of moving toward a softer rule or have already arrived. And so I think for a while, you're going to see a situation in which relators who might be litigating their cases declined will be looking to bring those cases in the courts with the more favorable rules. This problem doesn't tend to affect the government very much because it has access to specific claims data and can always put it in its complaint. And so for relators who are really just looking for intervention or bust, it probably won't matter that much. But for everybody else, this will be a big deal in terms of where you choose to bring cases.
And there are 2 petitions still pending at the Supreme Court in Proctor versus Safeway and Schutte versus SuperValue, dealing with a knowing violation of the FCA. Tejinder, what's the status here?
This is interesting. So this is the knowledge question that goes to whether the Safeco standard applies to the False Claims Act. The Seventh Circuit said that the answer is yes, so that defendants' subjective beliefs are irrelevant to the scienter inquiry. The only thing that matters is, can you shoehorn the defendant's conduct into an objectively reasonable interpretation of the law it violated? And if you can, then the defendant can't be held liable. There was recently a Fourth Circuit case that went en banc about this, and the Fourth Circuit threw up its hands. The court split 7-7 and said, yeah, we don't know, and issued no opinion. There have been these cert petitions pending at the Supreme Court. The court has called for the views of the Solicitor General in the Schutte case. That brief is going to be filed in December. In the meantime, the Proctor case, which is sort of a follow-on from the Seventh Circuit, is moving through the certiorari briefing process. Not yet fully briefed, but I expect what will happen is that the court will hold that petition pending the resolution of Schutte and decide them both together, granting certiorari in both, one or none.
And there's a new petition filed with the Supreme Court, Pfizer Inc., U.S. Department of Health and Human Services. Tell us about this case. This deals with the anti-kickback statute.
Yeah, Pfizer is not an FCA case at all, but it's about the anti-kickback statute, which is, of course, a predicate for many, many FCA cases. And Pfizer is really taking aim here at what I would describe as the core of the statute. They're saying, look, it can't be enough under the AKS for us to give kickbacks to people intending for them to use our services more. You have to show that we are trying to corrupt their medical decision making. We're trying to graft an element onto the anti-kickback statute, which currently is sort of an intent trigger. And there is a lot of amicus briefs supporting this, but what's really interesting about the petition to me is that it is full of policy arguments. Really, they're not shy about saying that they basically just have like a policy view on what the anti-kickback statute should mean. And I think they're trying to see if there's a sympathetic pool of Supreme Court justices out there who might want to rule in their favor, notwithstanding the text and how the statute has been interpreted pretty consistently since its inception. There's no real split about this. None of the traditional cert criteria are met. They're just sort of casting a line and seeing if they can hook a fish on their policy arguments. And we'll see how that goes. That petition is not yet fully briefed either.
Finally, let's talk about Polansky versus Executive Health Resources. There is an oral argument coming up on the 6th of December. Tejinder, tell us about this.
Right. So oral argument in this case is going to be interesting. This is a case about whether and when the government can move to dismiss a relator's FCA action under the C2A provision. And the relator's frontline argument is an interesting one. It's that after the government declines to intervene, it cannot come back subsequently and move to dismiss the action at all. The statute does not permit it to do that. It gets a chance to do so at the outset of the case before it declines, but if it passes on that, it can't come back. The interesting thing about oral argument to me will be to see if there's any interest from the justices in that position. That's not a holding that any court has embraced so far. But one thing that those of us who are FCA practitioners can sometimes miss is that when the Supreme Court picks up an FCA case, it treats it like any other statutory interpretation case. They're not following the FCA every single day and seeing what happens the way we are. They're not observing the trends among the courts of appeals. They're picking up the case for a day, figuring out what they think the right answer is and moving along. And if you look at the text of the statute, the relator's argument isn't crazy. And so I think it'll be interesting to see how much uptake it gets from the justices. The other interesting thing at oral argument will be to see if there is any interest in the argument raised by the private respondent that the relator's position might render the FCA unconstitutional. So those of us who are around in the 1990s, and I'm not one of them, will remember that there was a time when defendants were arguing that the FCA violated Article 2 of the Constitution because it gives too much power to relators and not enough power to the executive branch. And those arguments were pretty roundly rejected by the mid-90s. Pretty much every court of appeals had said, no, take that away. But then now there's an effort to revive the argument, and it pivots a little bit around this dismissal question. Does the government have enough control over a relator's action for the statute to pass constitutional muster? And the private respondent has said, if you adopt the relator's view, in this case, the statute would become unconstitutional. The relator has said, correctly, in my view, that that argument is crazy. But we will see if there's any interest among the justices in taking up that Article 2 question and maybe, pulling this zombie controversy from the 90s back out of the closet and seeing if it'll eat any brains. But that's the state of play, and that's what I'll be looking for as I watch the arguments.
Boy, a lot to look forward to in the new year. Tejinder, thank you. And thank each of you for joining us for the Federal Bar Association Key Tam Sections, the Rounds FCA News with Tejinder Singh. Happy holidays from Tejinder and from me. We'll see you in the new year.